Ms. Sencer?
Thank you for having me. This is my fourth panel here, but I'll reintroduce myself. It's my first one today. My name is Karen Sencer. I'm a shareholder at Weinberg, Roger, and Rosenfeld. We're a labor firm based in Alameda, California, 4 offices, lots of clients up and down the West Coast, mainly in California and Hawaii and the rest of the western states. I'm going to start at a different point. I think that regardless of format that it winds up in, at the very least, the standing Excelsior list rule should be formalized. And the reason I say that is, although it's been in place for 50 years and has not been disturbed, this agency tends to have some flip-flop decisions in its history. And to protect it, regardless of what the membership of the board is at any given time, that very basic provision in some format should be protected. I do, of course, advocate for it including more information than the home address, or the address as it is. The address is not really a great way to get in touch with people, and nor does the list that you receive doesn't necessarily even include a home address. One thing that I see frequently with one of the client groups that I work with is they have a lot of seasonal workers that they're organizing. National Labor Relations Board covered, but somewhat agricultural related, packing houses, salad plants, those types of things. Migrant work, sometimes migrant work for the same employer throughout the year, but at 3 different locations for the same employer throughout the year. For purposes of what they give the employer for an address, they receive their check every week by hand, but their listed address is a P.O. box. And when you're organizing, you can't go visit somebody at a P.O. box. The Agricultural Labor Relations Board, which you've heard me talk about before, requires that the employer provide an actual residence to the union within 2 days. The employer in that case, does have to go out of their way to find that address, but it actually requires a street address to be provided, so there's actually a way to have communication. In those same industries, you find that employees are not recalled to their seasonal work by means of a letter to their P.O. box. They are recalled by means of a call to their cell phone. It just seems like a logical output of that, or a logical extension of that, to have that same method of communication that the employer uses to reach the employee be the method that's given to the union as a way to reach the employee. And it doesn't seem particularly radical. I also advocate for the inclusion of the shift. And I know some people have said that they think this might give rise to something like increased property theft. Now, if the union is doing their job in organizing, they should be learning what the shifts are about anyway. But earlier on the campaign, it actually becomes less disruptive to the rest of the family if the union has the information regarding the shift. It's less disruptive to the rest of the family because then the union representatives are not visiting at a time where they know that I'm not there. They know that I work nights, let's say. Let's say I work in a 24-hour facility and I work nights. If they come and knock on my door at 8 o'clock in the morning, they've probably disrupted my sleep cycle, which makes it harder for me to perform my job the next day and may interrupt anything else that's going on inside my home. So having the shift information there would be quite helpful in ensuring that the rest of the family, as well as the sleep schedule of employees who work on something other than the 9 to 5 shift, are not disrupted by visits from union representatives. The Ag Board, again, also requires these lists to be produced by 2 days. It's not particularly burdensome. Most employers keep some type of electronic record keeping now, and they use those electronic record keeping for their payroll system, amongst other things. Larger employers or employers who have part-time help have even more of a reason that this information is digitized in some way so that it's easily accessible when they need to call additional employees in. Producing these kinds of lists and producing them in a short time frame is not particularly overwhelming. There was one question that was raised earlier regarding people who are challenged and are going to be challenged and how that would be dealt with if there are more challenges. And in the current situation, when there is a stipulated election agreement and some people are voting by challenge due to the agreement of the parties, those people show up on the Excelsior list, even if they are going to be challenged. I don't see why this raises any more concern that there's a couple more people on that list who will vote as challenged ballots but will still show up on the Excelsior list. In short, I think the board's rule actually should be more broadly stated to provide all contact information or any contact information that the employer may have, and that way you're not tied down to how the technology may change over time and what methods of communication might be available to the employer and therefore to the union by extension. Thank you.
In your experience, do you know whether or not employers have an obligation to keep a list relative to shifts and hours worked and contact based on responsibilities for wage and hour or other governmental agencies?
For some things they do, and for some things they don't. I do a lot of work with Teamsters. There's a lot of drivers involved. They always know the hours that they work because they're subject to the DOT hours of service regulations, so they always know what they are. The same is true if you work with anyone who's in healthcare. They need to know how many hours healthcare staff has been on shift because they'd like to make sure that they get rest for patient safety concerns. They also know how many are going to be on shift because they have ratios that they have to keep. So to some degree, that really depends on the industry and whether or not there's other regulation that require them to keep it. But they tend to keep that information because they want to make sure they don't violate basic things like overtime requirements, too. So they always know how many hours a week employees are going to be working.
Okay. Thank you.
One quick follow-up. Although California is sort of my adopted state before I came back here, it would be fair to say that employers are very heavily regulated in California, so they have to keep this information in many dimensions, right?
Yes.
And it would also be fair to say that the employees you're talking about are essentially seasonal or migratory, so the opportunity for the union to communicate with them in terms of physical space is fairly limited because they're moving around.
Yes and no, to some degree, because many of the unions that do organizing of groups who have migrant labor, they have offices that are set up in each of the areas where they may be working throughout the year, organizers who are down in those areas. And depending on the length of the season, some of these seasons can be longer than others. So, I found out recently that baklava has a season. It's a couple of months in the early fall.
So we're not in season yet?
We're not in season
Right.
yet, but it turns out they have a season, and they have the same people, and this particular facility has the same people who come back every year to work in it, who actually do live in the area. They just have other jobs the rest of the year. So in that case, the physical address would be really helpful, but other information would be very, very helpful. When it comes to a salad plant where there's 3 locations, I think of the ones who are in Yuma and El Centro and in Salinas, across 2 states, right?
Right.
Those people all use P.O. boxes and cell phones.
But most of the workers we regulate are not nomadic, essentially.
I would say most, but not all. These are people who are covered by the National
Right.
Labor Relations Act.
I understand. And California's made a different call, essentially, on privacy versus union access. There was basically the L.A. County versus La Serra case, which was a big one that came down last year. But even in that case, the California Supreme Court said nothing in the relevant statutes or case law appears to prohibit agencies, such as PERB or IRCOM, 2 of the public equivalents of us, from developing notice and opt-out procedures that would allow employees to preserve the confidentiality of their home addresses and telephone numbers. So even in California, the Supreme Court gave a nod to the consideration here of privacy.
And there is always a consideration of privacy, but it's a balancing act that you're always trying to strive between. I'm going to anticipate that a question might be asked about the opt-out versus opt-in on this, and I think that an opt-out, if either are being considered, that an opt-out makes it easier for an employee to make a fully informed choice. And it is less of a way for the employer to take the pulse of the bargaining unit regarding what they want. If you have to opt in through the employer, that is subject to all kinds of pressure on the employee for making their voice known.
Right. One might say it's equivalent to handing out, union-related hats, for example, and seeing who takes the hat and who doesn't.
But it's okay for the union to take the pulse of the bargaining unit. Under current law, it's not okay for the employer
No, right.
to do
That's
it,
what I'm saying.
you
If
know.
the employer is the one that's in charge of deciding who's or monitoring who's opting in and who's opting out.
Yes.
Okay.
Thank you very much.
Thank you.